help the respondent number one to respond.
My lord.
Is that all right? No, Mr.
Sir, yes, I can begin do that straight away.
So then we will allow his request, and we will try to incorporate whatever you say today. Naturally, you may want to add something later, but then he'll be hearing himself. But it will give the respondent number one time to absorb and respond to them also.
And if your lordship wants to facilitate him further, I can, and to save your lordship's time, instead of submitting that orally, by early tomorrow, give a list of propositions and provide it to the court staff, and those can be communicated to him. Whichever way your lordship pleases. I can articulate them now, or I can give them in writing by tomorrow morning.
तुम सब हम तो देख लेना
जी सर, मैं अभी
हम आगे ट्रांसमिट करते हैं.
Can you just since we've assembled, we don't want to waste this day. We may do both.
By law.
We may also then call upon you to write them down later. You may want to think, but so can we hear you,
my lord,
on the fundamental questions?
My lord, let me begin straight away.
Don't go into the facts,
no.
Just the legal proposition.
Just the legal proposition.
Makhdoom Sahab,
sir, my lord.
Speaking for myself, there's one appeal by the federal government,
my lord,
and the others are by private person.
My lord.
Section 5 of the Act जो है, Practice and Procedure, my understanding is that only an aggrieved person can file an appeal. So how is the Federation aggrieved?
My lord, because a statute of the Federation was struck down.
Sorry, आपका आवाज.
My lord, two reasons. One, the Federation was the respondent, and it was a statute, federal statute, which was struck down. So if the Federation is not a respondent, then in that event, in a situation like this, where NAB didn't come forward as an appellant, then virtually every decision made by the court would be final and there would be no right of appeal. And your lordship knows that even if we move away from 184.3, wherever statutes are struck down under 199 by the High Court, constitution petitions are filed under Article 185 of the Constitution and have been heard by this honorable court, and the Federation has never been non-suited on that ground.
Here we have to interpret Section 5 of the Practice and Procedure Act.
Yes, ma'am.
Subsection 2 was in fact struck down by this court.
Yes.
But when you read subsection 1 and subsection 2,
yes, my lord,
it is an aggrieved person. And this court consistently has interpreted the expression aggrieved person as a person who has suffered a loss. A department or the government has not been treated as an aggrieved person for the purposes of an appeal.
If your lordship may see Section 5.
I think there are two slight variations to the proposition. The first variation is any party to litigation, if a case is decided against him, will be presumed to be an aggrieved person. There may be third parties who may come forward and say, I am aggrieved by this person. In my opinion, those persons will have to show how are you aggrieved, as opposed to every petition that is filed, I'm aggrieved by this judgment. We don't delve into the question, how are you aggrieved by this judgment, if he's a party. If he's not a party, then HM principle applies or not. Then we ask him how you aggrieve. You are a party, it is taken that you are an aggrieved person. Otherwise, that party would not have been arrayed as a party to begin with.
My lord,
so why did the petitioner make him a party?
On same principle, we are allowing the respondent to appear and to argue the matter.
And may I also...
One thing more, Mr. Who proposed these amendments to the Parliament?
My lord, I'll come to that in a moment. May I just draw your lordship's attention to Section 5 itself, and your lordship will see that the word aggrieved person is missing from there.
But the fact is, again, this debate will become academic since you are one of the petitioners yourself. There are the private parties as petitioners themselves.
Yes, my lord.
So can we have your propositions?
My lord, yes.
Ji.
My lord, my first proposition before your lordship is that during the pendency of this petition, the Practice and Procedure Act of this honorable court was enacted. And with that enaction, we made...
Even if you now you come back to the Practice and Procedure Act, please read Section 5.
My lord, yes.
पढ़ दें उसको.
An appeal shall lie within 30 days from an order of a bench exercising jurisdiction under clause 3 of Article 184 of the Constitution to a larger bench of the Supreme Court, and such appeal shall, within a period not exceeding 14 days, be fixed for hearing. And that's what I was submitting.
And please read subsection 2 as well.
Subsection 2, which has now been...
it has not been upheld by majority.
Yes, the right of appeal under subsection 1 shall, and I emphasize the word, also be available to an aggrieved person against whom an order has been made under clause 3 of Article 184 of the Constitution prior to the commencement of this.
So it's only
not part of the statute.
It adds the aggrieved person. You say it adds the aggrieved person.
It broadens the definition.
Yes, my lord, but the word also, and your lordship will know that right from Fazaldeen's case in 1969, even the definition of an aggrieved person, which now is there under Article 199 of the Constitution, this honorable court in questions relating to fundamental rights has taken a relaxed view of that. And one of the principal distinctions being pointed out between 199 and 184 3 is that under 199 you have many of the other trappings, as they are called, where the court can regulate the jurisdiction. The word aggrieved person is missing from Article 184.3, which is there under Article 199. My lord,
इसमें मखदूम साहब, this is a statutory appeal.
My lord, yes.
Statutory appeal में, in case of Customs Act, there are 3 judgments of this court, 3-member benches, where the Custom Act only then had provided a right of appeal either to the collector or an aggrieved person.
Yes,
the Director Intelligence had filed an appeal, and this court held, and it was the argument of director that I'm an aggrieved person. This court held, you may have been disappointed with the judgment or the order, but you cannot be an aggrieved person because no personal loss has been suffered.